Linden to the Department of Corrections for a term of not less than 5 years, nor more than 15 years, exercising my discretion under the habitual court statute.
As Mr. Hartman stated, it's also to give them second chances, and I believe that I gave Mr. Linden a second, a third, maybe even a fourth chance. Deterrence, though, is also goal sentencing, as stated in the PSI that Mr. Linden.
Given this track record, I believe that a 5-year minimum is more proportionate to the seriousness of the offenses in this offender than would be a guideline sentence. (25-6964) Counsel, please state your appearances.
Melissa Goodrich, Wayne County Prosecutor.
Daniel Hartman on behalf of Mr. Linden.
Okay, and I saw you had substituted on the case. I have had a chance to review a letter from Pastor Stephen Jones and also your sentencing memorandum. Thank you for that. Have you had a chance to review the probation violation recommendation report with your client?
Yes, Your Honor. We have the report dated 7/17/2026, and it was reviewed with my client.
All right. Do you have any additions or corrections to that report?
We do not.
The initial guidelines had been scored at 2 to 34 months, 5 to 46 months, 10 to 46 months in the 3 files respectively. Any defense request to revisit that initial scoring?
No.
Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
Mr. Hartman, anything you want to say in your client's behalf?
Yes, Your Honor. I had a lot to say. That's why I decided to write a memo, which I don't often do. First thing I would want to talk about is put some information in there related to the problems that we have with addiction in this society, and also the evolution of the way treatment courts and courts are looking at that. Mr. Linden and I would like to thank the court for the opportunity to participate in the drug court, where while it looks like a failure, that is on a pass-fail grade. He did learn a lot of things, and he did participate for a period of time, including some of the longest periods of abstinence that he's had. Your Honor, the drug is a very dangerous drug. And as a dangerous drug, it's classified that way because of its addictive nature. And he's caught in that addiction. And unfortunately, he has some impulse controls, but I just want the court to know that the needle did move. He had many successes and many accomplishments in that program. And his journey in life and his journey in recovery is not over. One thing he has suggested to me, and he asked me to ask the court, is the opportunity to go to treatment. I know he's had treatments. I know that treatment is something that the court has tried. And I do recognize that the recommended sentence is focused on shall we say, an unsuccessful discharge of probation and completion. And he did like the accountability of the program. I did have a chance to also interview his mother. I know that he was working, and he's a productive member of society. And but for this cross that he bears of the addiction, which is part self-inflicted and when it started, in part something that he has struggled to control, it's that fine line of where the criminality is. I say this because he's accepted responsibility for the choices that he made. He made it in weakness. He didn't turn to his supports, and he had some failure. And Your Honor, this consequence that he's facing, and the being kicked out of the program and having to go and face a incarceration for some period of time has really once again galvanized what he's thinking about. So Your Honor, he's asked me to ask you if he completed a 90-day program. And after that, if he could serve some time on work release. I do get a chance to speak to Ms. Goodrich, and she obviously thinks that he's had a significant number of chances. He's got 3 cases here, and I can't say anything about what she's going to say is wrong, other than that there's a fundamental approach difference in how I look at this. She's been called by society and put in a position to hold people accountable. And I'm from this side. I am asking this court, I'm advocating for an opportunity for Justin to be able to complete the journey that he has started in drug court and to face a sanction for his behavior, but yet, Your Honor, recognize that on balance, he had an incredible business going, incredible job, incredible community record, and he used. And one of the really ironic things that you want in life is some tough love and some people hold you accountable. His mother did that. And, obviously, when that call was made, it's a difficult situation for her. It's a difficult decision for him. He's come to grips with it. And, Your Honor, I put some information in there to talk about whether incarceration is the right approach for this. And I do recognize there are sentencing guidelines, and I want to now just turn to the law. The sentencing guideline in this case is a straddle cell. In a straddle cell, this court can give an intermediate sanction of 0 jail days all the way up to a year, and that's what we are asking for. The Department of Corrections has processes for when they make recommendations for prison. And if you look at his criminal record, which is drugs, you can look at him and say he's a repeat offender. What he is he's an addict, Your Honor. He's an addict who started a journey of help. The drug court has helped him. He was not successful in that program, but his journey is not there. Now, Your Honor, when I first got asked to come into this case, one of the things that I want the court to know is I looked and see whether we still have Swift Insure as an alternative. You do not. So that might be a good program or a program alternative, but then the guidelines and the report came down. And Your Honor, I'm asking this court to consider whether he can go to treatment and whether he can come back and serve his jail time. I think the treatment up front, while he is accountable, and then he can have work release in a supervised setting where he's coming into the jail and being tested, makes the most sense for the society, for a member of the community who's done his time in prison. And that obviously didn't correct the chemical and biological issues that happen with addiction. But I stand here before and tell you that this man is remorseful. He didn't mean to make light of the program or be disrespectful to the program, but he struggled with his addiction. And unfortunately, one of the triggering events of this was a person who came around and he made some bad choices. And Your Honor, he knows there's a consequence for that and would ask the court to focus on rehabilitation and to give him a county jail sentence that considers treatment as a first choice.
Thank you, Mr. Hurt. Mr. Linden, you don't have to say anything today, but you're welcome to. Is there anything that you want to tell me today or no?
Yeah, I just want to say, I was grateful to get an opportunity in the program, and I failed the program, but the Dan said I had a lot of success in the program. I was able to stay sober for over 13 and a half months. I've never been able to do that in my life. I've struggled with stimulant use since I was put on Ritalin at the age of 5, and it's an amphetamine. And once I got introduced to methamphetamine in prison, I don't know, just took over. It's a very dangerous drug, and I'm sorry that I relapsed, and I think I self-sabotaged myself. I just want to apologize to the court and everyone in the drug court program. You guys did help me a lot, and I wish I could have completed it on a successful level, but like I said, I did do a lot of good in the community. I help people. I try to help people here in jail. I'm doing the AA, NA in here, and whatever sanction you hand down, I'm just gonna do it and move on.
All right, thank you. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, thank you. The defendant is 46 years old. He's self-employed with 1 year in college. He has 14 felonies and 31 misdemeanors. His criminal history spans over 3 states. I counted at least 10 Michigan counties. It also spans over. He was on parole when he committed the 2 new cases. After he started recovery court, he additionally committed 2 more controlled substance cases. I know Mr. Hartman stated there's a fine line of criminality, but here we have somebody on parole who's given a second chance and then commits more cases. Also, the comments in the PSI on page 7 of 8 is that as the offender was in the final phase of the program, his behavior is quite indicative of his future choices. So I think we can look to his behavior thus far to predict what would happen in the future. In recovery court, we sent him to inpatient treatment twice, which doesn't often happen, in addition to all the other recovery court resources that we kept using to assist Mr. Linden. He's a very likable person. We wanted to see him succeed. In addition to continuing to use, he also manipulated tests with dilute results. Rehabilitation is a goal of sentencing, and I believe that was tried, probably even more than should have been. But the team, like I said, really wanted to see him succeed. While my job is to hold people accountable, as Mr. Hartman stated, it's also to give them second chances, and I believe that I gave Mr. Linden a second, a third, maybe even a fourth chance. Deterrence, though, is also a goal. Sentencing, as stated in the PSI, that Mr. Linden continues to place the community at risk by his behavior. He's already served 12-month sentences as recommended in the PSI here today. I think that ended in his phase of life, it looks like, in his criminal history about 2013. After 2013, he kept getting prison sentences. He served in prison 3 times, with the maximum one being 3 years. That was all before the present 2 cases committed while on parole. There are reasons to exceed the Michigan sentencing guidelines here, but I'm not asking the court to do that. I'm asking the court to order top of the guidelines in both cases, which would be 34 months and 46 months. Thank you.
Great, thank you. Well, Mr. Linden is here for sentencing today in file 6886 for tampering with an electronic monitoring device, habitual fourth. Guidelines of 2 to 34 months. That was committed while he was on parole out of Emmett County for serious felonies of repeat drunk driving and home invasion 3rd degree. And also in 6887, possession of methamphetamine, habitual fourth, with a guideline range of 5 to 46 months, again, while he was on parole in Emmett County. And then was placed in recovery court. And then while on bond for those 2 files, committed the felonies of possession of methamphetamine, buprenorphine, and a Schedule 5 substance in 6964. Those guidelines are 10 to 46 months. We continued Mr. Linden in recovery court despite that new felony committed as he was beginning the program. And we sent him to inpatient rehab, and he completed that in December of 2024. Also, he had used methamphetamine and gabapentin along with that, and that was wrapped into sending him to rehab. So, I mean, I think we really did try to, despite his criminal history and despite his crimes on bond and on parole, tried to be, forward-looking with the rehabilitative goals and continued him in the treatment court and sent him to inpatient rehab instead of removing him at that time or locking him up. When he was done, then we had a dilute test in February of 2025. Looks like 2 of them. Then in April of 2025, again, a relapse on methamphetamine. And rather than remove him from the program, we sent him to inpatient rehab a second time. And then in July of 2025, he missed a court date. We didn't do a warrant for his arrest. We gave him a sanction of spending a day in the jury box as a sanction. Then we did see, this is the time that I think Mr. Linden and his attorney are referring to. We saw a period of several months with compliance from Mr. Linden and saw some hopeful signs. And then in February of 2026, we had another dilute urine screen. We gave him community service. And then in March of 2026, he committed a new crime. It was a traffic misdemeanor of driving on a suspended license. We didn't remove him for the new criminal behavior. We didn't violate him. We didn't lock him up. We deferred to the district court for that sanction. And then in June, these violations, he had a dilute urine sample and again used methamphetamine. So, defendant was on parole for serious felonies when he got 2 felony cases. We gave him a chance with recovery court. He then caught another felony case. We didn't remove him, rolled that case into the program also. We sent him to inpatient rehab not once, but twice in response to violations. We didn't remove him when he got a misdemeanor driving on suspended license. He's had several violations. We didn't remove him. So, I mean, we really did not approach this with an old school lock him up mentality. We were trying to implement, a lot of the best practices for treatment courts and to Mr. Linden's credit, I mean, we did see him gain a little bit of traction there. But he had several violations. He did seem to make some progress, but what's really troubling to me is that at the stage he was in our program, he was diluting a urine screen, and then when he tested positive, he initially was lying about his relapse. And I mean, if he had been honest and forthright, perhaps despite the number of prior violations, we could have justified continuing to work with him. I don't know. But he took that decision kind of out of our hands by his deceptive behaviors. At this late stage of the program, his continued violations and deceptive response do show that it's time to remove him from the program. So I will revoke Mr. Linden's probation in all 3 files. I'll reimpose all fines and costs that were previously assessed in the amount of any unpaid balance. So then what do we do for the incarceration component? We got Stratostel guidelines, we got a recommendation from the department and from the defense for county time. We got the prosecutor wanting top end of the guidelines. Mr. Linden has 14 prior felonies and 31 prior misdemeanors. He was on parole at the time of these offenses. Looking at his criminal history, he continues to commit felony crimes while he's on parole, while he's on felony bond, and while he's on felony probation, or continues to violate felony probation. This sentencing today is for his 15th, 16th, 17th, 18th, and 19th felonies. That means in combination with your 31 prior misdemeanors, he's being sentenced today for what amounts to his 50th criminal conviction. Mr. Linden's first conviction was a misdemeanor retail fraud 2nd degree, pled down from a 1st degree felony in 1998 when he was only 18 years old. Looking at this extensive criminal history includes, by my count, 15 theft-related crimes, 10 impaired driving crimes, and half a dozen assaultive crimes, in addition to the drug crimes. So it's not just, I would disagree with the statement that he has a stellar community record except for drugs. He steals and drives high or drunk and assaults people. I mean, at some point, we gave him every chance. At some point, people in our society have the right to wonder how many chances society has to give someone who now has 50 criminal convictions. I honestly think these guidelines do not adequately account for that lifelong patterns of crimes, nor do they adequately account for Mr. Linden's extensive history of committing crimes, whether he's on bond, probation, or parole. It doesn't seem to stop him. Nothing seems to stop him. A pattern that's prevalent throughout his criminal history that now spans almost 3 decades. I mean, Mr. Linden's a likable guy. I agree with the prosecutor, and we had plenty of interactions with him in the time of the program, and I don't take any pleasure in this, but I think that these circumstances do indeed call for an upward departure. And given this track record, I believe that a 5-year minimum is more proportionate to the seriousness of the offenses in this offender than would be a guideline sentence. And this represents a moderate upward departure from the 46-month top end in file 6964. Also, MDOC recommends credit to which defendant, I believe, is not entitled because he was on parole with a detainer file. So the initial arrest credit in all 3 files, he was on parole with a detainer. I'm not going to give him those credits. So he's entitled to credit for 1 day for a violation arrest in April 2025 and 48 days since this violation arrest, for a total of 49 days credit in all 3 files. So in file 6886, I'm going to commit Mr. Linden to the Department of Corrections for a term of not less than 5 years, nor more than 15 years. Statute to increase the maximum with credit for 49 days. In file 6887, again, 5 years to 15 years, habitual 4th increase in the maximum from 10 to 15 years, credit for 49 days. In file 6964, on all 3 felonies, commit for 5 to 15 years, increasing the statutory maximum at my discretion under the habitual 4th statute, again with credit for 49 days. As I said, reimpose all fines and costs previously assessed in the amount of any unpaid balances. And I'm going to order all 3 of those files to run concurrent with each other. And since parole has been discharged, there's no consecutive sentencing that would apply to that. So, Mr. Linden, in all three of those files, we'll be entering judgments, so you can file an appeal if you wish by filing an application to the Court of Appeals. If you want a lawyer appointed, I would do that if you qualify, but you'd have to ask me within 6 months of today. We're going to hand you some paperwork in all three files. We're going to ask you to initial one copy in each of them, so we have a record we gave it to you. The other one is for you to fill out if you want to take an appeal. And good luck to you, Justin.
In a tense courtroom exchange, the judge showed clear frustration after learning that a key witness was discovered on the very day of trial. The court criticized the last-minute request for a delay and questioned how such an important witness had gone unnoticed for months. When it was revealed that people had been told to leave before the court officially adjourned, the judge responded sharply, reminding everyone that courtroom procedures must be respected. Although the trial was postponed, the judge issued a stern warning that no further unnecessary delays would be tolerated. The case will now return to court for trial.